Today, we are delighted to welcome Talha Abdul Rahman, Advocate-on-Record at Supreme Court of India and an author. A proud alumnus of Nalsar University of Law, Hyderabad, and he later furthered his legal studies at Oxford. Over the course of a career spanning more than 2 decades, he has appeared in major constitutional, administrative, and public interest cases across High Courts and Supreme Court. Recently, Talha also published his book, In Chambers, Stories of Lawyers and Lawyering, where he takes readers inside the professional and human side of the bar. I and Rashmika were going through one review on the leaflet which talked about how his book bridges the gap between what we study in theory and what we do in practice. And that is what what has brought us today with Sir today, and we are looking forward to have a discussion with him over his journey and about his book especially. And with this, my first question, and to start on a preliminary note, could you please share what was your motivation behind writing this book? I'm sure you put in a lot of effort and time because you handle a lot of cases on everyday basis. And I believe the audience would love to know what was your motivation behind it.
So thank you, Tamanna and Rashmika, for having me here. It's wonderful to get back to one's own college. This is the very place where I studied law. And this is the very place where in those times we used to spend long hours reading books and finding journal articles on JSTOR because we didn't have Wi-Fi back then. So we had to come to Computer Center, which is now converted into a beautiful studio. Things have changed, and that's the reason why I have written the book In Chambers, which is a young lawyer's guide to practice, ethics, and advocacy. To say that again, because the times have changed. You see, in the earlier days, when the number of lawyers were few, it was possible for one to get hold of a good law chamber, a good senior, and learn many things from the chambers. But now, what has happened over the years, I think, is the consumerization of the legal profession, where many things that you learn in chambers are not easily available or accessible to many law students, especially those from the first generations. I am also a first generation lawyer, and I realized that I was very fortunate to have received a lot of guidance, very strict ones from my bosses, and I felt that I should maybe attempt to pen it down so that those who are not so fortunate to have access to the same kind of gurus that I had access to are at least able to understand and experience the same kind of training to the extent possible, with the limitation that it is, after all, a printed, published material and not the kind of training that happens from one to another through interpersonal transference of knowledge.
So you talked about guru. I believe guru's value spans from in practice to in theory, and that brings me to the next question about the quality of teaching, which is a problem in every law school, I think. And if you could also talk about how the gap could be bridged with what is taught in theory and what you deal in practice in legal area.
So, Tamanna, your question has actually two limbs to it. One is about the quality of education in law schools, and the second is about the gap between theory and practice. So what I feel is, firstly, on the quality of legal education. Trust me, the quality of legal education is improving every day. And fortunately, so are the quality of the students wanting to get that knowledge. So when we were in law schools, all of us also thought that, we are not getting what we should. And even though many of us have, when I say many of us, is many of my juniors or my contemporaries have gotten back to teaching themselves. They have joined various law schools and universities. And even today, your contemporaries are complaining that the quality is not so good. So the answer is really that it's a continuous process. The quality has improved from what we had, but it's a process. It is going to get better with time. And the students' thirst for knowledge has also increased. Of course, it's a generational change that's going to happen. So what you need really is the change in approach. It's happening. It's a slow process, and as you age in this profession, you will realize what I'm saying today is something that you will possibly say to your next generation, that it's a process. Having said that, I think there is a need to understand that legal profession requires a constant search for answers.
Right.
Every case presents a new opportunity to unpack either the old notions or to unpack the new academic understanding and try and see if it fits in the statutory framework. The laws change, the legislative intent changes, the parliament brings out new laws, and in some cases even the constitutions change. So which means that what you can understand or learn in the law school is not the text of the law, because the text of the law is today something else, tomorrow it may be something else. What you can really learn are two things. One is the basic principles of law, first principles of law that hopefully don't change. And second is where to find the law. So when the client comes to you posing a problem that this is my fact situation, you have to know what are the various sets of laws that are applicable to it. It may be Companies Act at one point of time, it may be insolvency regime at the current point of time. If you go back several years, it may be the BIFR regime, for example. But the fact situation remains the same. The laws evolve, the laws change. So the biggest thing that all of us need to learn in the law school is where to find the law, and number two, how to find it. So, and that is why there is so much emphasis on research and trying to understand that this is the fact situation, which is, by the way, the kind of questions that you get in your final semester examinations is also a problem. You have to figure out what is the various sets of laws that apply and what could be the answer in that fact situation. So the idea is not to ask you, give me 5 kinds of writs that are can be issued. Those are very basic, elementary kind of questions that you can, open any basic constitutional law book, you'll get the answers to. But the real answer is unpacking the problem, unpacking the factual situation. That is what we have to learn. Learning the text of the law or memorizing the case laws is all part of the process, but that's not the end part of it. And this is the solution for the gap between theory and practice. One of the fundamental things to learn in practice is what to say next. How to modulate and how to pitch what kind of answer or what kind of argument before which judge, and what is the stage for it. For example, if you file a civil suit, on the first day usually summons will be issued. Now, whether or not now you may as a defendant receive your copy of the summons with the plaint, and you may on the first day want to argue a brilliant point of, I want to get this suit dismissed. But there is a method in which how that will happen. That method is provided for in CPC. So you have to understand that the whole of law will not operate on that one particular date. You have to understand how the courts function. What is it that the court is wanting you to do on one day? And also, if you want a certain outcome, what are the steps that you have to take to get to that outcome? And that is where the blending of the theory with the practice takes place. Now, a part of it you're supposed to learn in internship, and the part of it, and in fact a large part of it, is something that you're going to learn from the case law method. The case law method is nothing but other people or other lawyers and litigants experimenting with a fact situation, applying a set of laws, doing it right or making mistakes. Those mistakes either eventually catch them and the entire proceedings are then lost, or they succeed. And another situation in the same or similar kind of fact situation, somebody would choose a different kind of method, would reach a completely different outcome eventually. So it's the theory plus the process that is taking you to a particular outcome. So if you are, from a litigator's point of view, and which is how I remember reading law, because I wanted to litigate right from the very beginning of my law school life. I read case laws from the point of view of them being examples of how to go about it. So a fact situation poses a problem. What do I do to get out of the problem? What did the defendant do? What did the plaintiff do? What happened? And how is it that the outcome can be altered? These are all things that you have to learn from the case laws. Case laws are other people's lived stories. And that's how you have to really yourself bridge the gap between theory and practice. If you think that your teachers are going to tell you what is the point of how do you argue before a judge, nobody is going to do that for you. Even when you join a chambers, nobody is going to teach you that this is the point you should argue, this is how you should frame it, this is the sentence. That's too micromanaged. That's something that you have to pick up on your own. And that's the part of learning that happens while you're on the job, while you're sitting inside the courtroom and learning from other people. So that's how I think this should work.
So you have clearly elaborated upon how to bridge the gap between theory and practice, and you said that case laws are lived experiences of people, which is a beautiful line. And this also, you mentioned that how times have changed and how you studied is very different from how we are studying, how the method of studies have changed, and how even the use of AI has increased. And with this, I would like Rashmika to bring up the next question about AI and please, Rashmika.
So definitely with ChatGPT, Gemini, every LLM model that is available today, learning has transformed a lot. And I just would like to read a sentence out of your book, which I found very beautiful, and I would love for you to elaborate on that. As long as you're using AI as a slave, it is acceptable. So from what I gather from this is, you want us to relate to AI or use AI in a capacity of master and slave relationship. I would love for you to elaborate more on how can students, or even for that matter, young professionals, use AI in a way, that enhances their work and their efforts.
Thank you, Rashmika. That's a very contemporary and relevant question. First of all, I feel that the way computers have changed not only legal profession but every work, every kind of work that human beings are doing, AI is going to do the same. So I don't think there is any point in trying to shy away from the AI. It is here and it is here to stay. The only question then remains is that what should be the relationship between AI and human beings.
True.
Now one needs to understand that artificial intelligence is an oversimplified concept. For our understanding, beneath this there are various kinds of technologies that operate, some of which are not very fair. One example is that AI, nobody knows what is the decision-making process adopted when you ask AI to do something or ask AI to reason out something.
True.
So you ask a question, you get the answer, but how is the answer arrived at is something that nobody has been able to explain, and that's the black box paradox in the context of studying about AI.
I think just to add,
Sure.
There's also some term called as AI psychosis, wherein no matter what you say, AI reaffirms you. Perhaps not only can it not reason why it's reaching to a certain argument or solution, there's also a good chance that probably there is some flawed reasoning in your argument and it won't be able to tell you why, and it would just rather reaffirm whatever you're saying.
That's entirely possible, and that's the reason why the AI should be used, if at all, with great circumspection and with an understanding that it is not really going to help either give you reasons or generate any accurate outcomes. it learns from whatever is there around it, whatever material is fed to it. So the basic principle that used to be applied to programming at one point of time, which is garbage in, garbage out, will apply to artificial intelligence also at present. Well, the technology may evolve, may change, may improve, but right now that's the limitation. Now, how to use it? Usually, the thing is, I don't recommend using it because at a certain level it does make you dependent on it. So but the point is that everybody is using it, and the teachers who are expecting you to give an assignment are also faced with a problem where the output is AI generated, and the same is beginning to happen in the legal profession also. Just the other day, Delhi High Court, somebody had to withdraw the whole petition because the citations were fake. So things like that are happening, then that's true. So the way to use it is really, like I described in the book also, is to have a relationship where you're asking it to do things, very mechanical things for you, or asking or engaging with it as somebody who can bounce back your thoughts. For example, you can frame a sentence and say, this is the sentence I've written, what is the flaw in it? Or this is the sentence, this is the paragraph, break it down into 4 parts for me to easily understand it. Right? Or you can give it a sentence and say, is there any better way to write it?
Enhancement.
Yes. Or one of the ways in which I see a lot of people using it is, just to, you've written something, you think that there are repetitions in it, just ask in that sense to Copilot, for example, where are the repetitions? Because repetition is something that you should avoid in your, so you may be so involved in drafting process that you may not be able to see the repetitions. But that's something that you can use the tech for the purpose of cutting it out. And then saving somebody else's time who's going to review that work. So that's something that's going to happen. But first and foremost is to understand the limitation that whatever it's saying may not be correct. So never rely on it for any citations. Do not substitute it for what is given to you. So if you have to read an order and find flaws in that order because you have to challenge and make ground for appeal, you should not feed that order in ChatGPT and say, please tell me the grounds of appeal. Because otherwise you lose the edge and then you will not be able to visualize all the situation. So like the case law method, the case laws will tell you that in that situation, this is what should have been done, was not done. And that's something for you to remember. And then that's something for you to find out in the next order. Now, the reason why I think that it's very important for all of us to be completely hands-on with our own understanding of the text is because in the courtroom, when you're standing to answer the question or you're there to submit your client's case, you have to answer for everything that is there from first page till the last page. Any errors, you're responsible. Any questions, you have to answer them. There is no AI available to you at that point of time to answer those questions. So if your understanding or your assessment of which side the judge is going to go and accordingly to keep the annexures there and keep the underlying story ready is half cooked or half baked because half of the work was outsourced to somebody else, you will not be able to answer those questions. So there is in this profession no substitute for reading. Even the most of the senior advocates who are there, who get briefed at the last minute, even though they may ask their juniors for the notes, they may ask the instructing counsel for pointers on what they think the problem areas are. There is no substitute, and they have, or at least they are expected to read the brief cover to cover, because when they are standing at the dais, it's their reputation that is at stake. And if the judge says, Mr. So-and-so, you haven't read the brief entirely because you do not know what is there at page 168 and you can't answer it, the reputation is gone and it's irrecoverable. So it is your reputation which is at stake. So you have to prepare well. You can't rely on either any kind of assistance, either human or AI for that purpose.
So you really elaborated upon how AI could be used in the contemporary world, and while we are on contemporary lens, I want you to move back and talk about the traditions of court and how our generation, which is coming up, the new Gen Z generation, which is the future, which are the future lawyers, how do you think they could do better in knowing the professionalism, the ethics of court, the traditions of court?
Yeah, just to add on to that, it would be really lovely if you could give us like what exactly is etiquette of courtroom. What are courtroom etiquettes? Just I'll tell you my personal experience. While I was interning in my semester 1, I was told by an advocate, this was in City Civil Court, I was told by an advocate that you have to button up your blazer, otherwise it's very disrespectful for the judge. I couldn't comprehend that, and somebody else the other day during that same internship came and told, you have to plait your hair, it's very disrespectful for the judge. We, like, as students, when we are like at the very nascent stage of becoming lawyers, we do not know these unwritten rules or the unsaid rules. So if you could tell us more about what is exactly courtroom etiquette, that would be really helpful.
Well, thank you for that question. And in fact, to begin answering that question, I must confess that I don't know the entirety of it. I just happen to be in places where I've seen my seniors follow some of those rules of etiquette. Therefore, some of them I've mentioned here. And the others are still unwritten. I hope that at some point somebody embarks a project of documenting the oral traditions of the court. The other day, for example, specifically on dressing, you see earlier if a lawyer was not dressed properly for the court, he was not attired properly, the band was missing, or he was not wearing a gown. So the judges would say that, look, Mr. So-and-so, we can't see you. Which was a way of saying that, look, we can't see you because you're not attired for the court. So you go out, get attired, and then come back. So we can't see you is a way of saying that, look, you're not attired properly for the court. Various other small things that are happening, which are all in the nature of traditions, and traditions can vary from one court to another. We have inherited largely a system that's from the UK, but we have also improvised on our own Indian cultural ethics that have found their way into the legal profession. Two more examples that I can give on traditions of the court. One is, if you are the last lawyer left in the courtroom or one of the last lawyers in the courtroom, you should not leave the courtroom before the judge does.
Okay.
So you wait till the judge leaves the courtroom and then you leave. So at least in the Supreme Court and in the High Court also, the judge should not have to see an empty courtroom.
Okay.
So if it's your last matter, you wait till the ushers come in, then they will take the judge inside, and that's when you leave the court. So if the judge is rising, for example, it's 4 o'clock, it's 3:58, 3:59, even if there are 3 or 4 more people in the courtroom, or if the court is packed, just wait for 1 or 2 more minutes, let the judge go, and then you go home. So that's something that's followed. And the way I learned about it is, I think it was Justice Shivakirti Singh's court, and we were about 3:55, 3:57, and our matter was passed over, and I was assisting my former senior, Mr. Gopal Subramaniam, and we were done with our matter, but he stood there like this, and I told him, I said, sir, let's go home. He said, just wait. And then then the judge went, and then he came out and he said, look, that this is the tradition, and that's you never leave the courtroom until the judge is gone, when you are last or few of the last lawyers left. And so that's the practice that all of his chamber colleagues then sort of know and they understood. So that's one example. The other example is something that Justice Nagaratna had given in court. And she said that, if judgment is pronounced, then out of courtesy to the judge who had reserved the judgment, the lawyers, even if you're not engaged for the day, to be present when your judgment in your matter is pronounced, out of courtesy to the judge, you have to be present for the pronouncement. And if you lose, you are at liberty to go after the judgment is pronounced, and you bow and you sort of go. But if you succeed, then you sit down in that court for a couple of seconds at least, just then bow to the judge and then leave. So this is something that she narrated, and and she also has a legacy of being from a lawyer in judge's family. So these are all traditions of the bar. I'm sure at some point somebody will document these. It's a hard thing because it's like you said, it's a lost tradition, but people are attempting to revive it by having a conversation like this. For example, I mentioned it. I also keep reminding my own juniors that this is how you have to do. One of the things that escapes people's attention is you should not move around in the courtroom showing your back to the court. That's also something that I learned in the first semester when I was interning in the trial court in Faizabad, my hometown. This was
something I was also told.
Yeah, because I was standing and I was addressing my senior with whom I was interning at the time, and I happened to face him, and my back was towards the court, and he immediately corrected me and said, look, your back should never be to the court. So now I also correct my juniors and my colleagues that never put your back to the judge, except when you bow and you sort of leave, then there's no other option. But generally speaking, when you're moving around in the courtroom, don't do that. So these are things, some very, very few of them I've mentioned here. I'm sure there'll be a project at some point where we'll collect, because we have to engage with the senior lawyers to collect these pearls and then put them, weave them together.
So I think there's one more example I could give. While I was interning at Supreme Court under Geeta Rutra, she only told me that you are going inside the courtroom and coming out very frequently, like going in, going out, and that would disturb the court, that would disturb the judge itself, and that you should be mindful of that. And that was also something that I wanted to add here.
Yeah, of course. So that could be, yes.
So thank you so much for telling us, and I am sure that it would help young lawyers and young interns like us who would be interning in the future. With this, my next question comes around the communication chapter that you have talked about in your book. Could you just elaborate on that?
So I feel, it's better for NLUs because I feel that the language is slightly better over there. But for the others, I've felt that generally communication skills are something that needs a lot of working. And our entire profession rests on communication, whether it is written or it is verbal. Either you're speaking to somebody, to the judge maybe later on, but speaking to colleagues, speaking to a client, speaking to people in the court staff, then eventually speaking to the judge. So, and it's about communication, how you say things, what you say, when you say. Secondly, when it comes to writing as well, we fail to understand that there are different kinds of writing. So, for example, I have had emails which will use shall as frequently as they will possibly use it in maybe a plaint or a written statement, or maybe in a statutory drafting. So people need to understand that there are different kinds of written communication, and there are different kinds of verbal and oral communication, all meant for different context. One example that I'm not sure if I've mentioned it in my book. One example was that when I was A0 in AZB, our job was also to come back and write, communicate to the client that we went to the court to represent you. This is what has happened, and this is what we feel should be the next course of action. So, and that email was to go from the team. So usually A0s and A1s would get the responsibility of putting it out, the first draft. So when I took my draft to the partner, he felt that it was very long. I said, look, it's long because so many things have happened and I need to say it. He says, finally the communication, his advice to me was that, look, your clients are people who will possibly read their emails on BlackBerry, because they are very busy to, even sit on a computer to look at the emails. So when somebody is reading their emails on a small handheld device, it can't be very long. just give a quick summary of what happened. Then if you want to say that, the further details are below. So, whether he wants to read the details, leave it up to him. But give him like a bird's eye view of what snapshot, what your email is going to be about. Now, so as a consequence of that, now when I am writing an email, I know that, even if it's meant for somebody, I have to specify in the opening few sentences that, what is the email going to be about, rather than, scrolling through all the way to the last paragraph and then say, what is it about? Right. So, these are small things that make a lot of difference. And, the similar thing that has happened in litigation also, I think we need to all realize that even though we are using 1908 CPC as the draft, but because of the docket explosion, everybody's patience with reading much has gone down, because, judges have to read a lot. Everybody has to read a lot. So because of that, the pleadings cannot be as long as they could be. You have to cut it short, and you have to say the relevant sentences in fewest possible words. It has to be sharp. You have to take out time to write shorter words, shorter sentences and paragraphs. It takes time to write less. To write more is easy. Mm-hmm. So that's the kind of approach I think that overall, in terms of developing communication, that one should work in. And I think if anybody is interested in law, in the 5 years or 3 years that they get, they should really work very hard towards improving their communication skills. Whether it is in writing or it is in oral, it has to be as good as possible. It has to be whatever best you can do it in your 5 years of your time. Point is that, in law school, we often spend so much time reading just about the law and the text of the law and, various other things, that we forget about the soft skills that are very important, because you may know all the law, but if you don't know the manner to present it, it's all gone. And that is what happens in the internships also. If, for example, in internship, somebody is given a research memo to make. The research memo is completely missing the point, because they're saying everything else, but not the research point, or the purpose for which the memo is made. Now, in an office, a memo could be made for various different reasons. It could be made for client, it can be made for briefing, it can be made for internal consumption, it can be like a memorandum of just the documents that are available in office. So you have to understand what is the purpose of a memo, and then accordingly build a piece just around it, tailored to the specific need, because you have to understand that the purpose of that note is to communicate, and then to whom. So, it's a process of learning that happens, and all of us come from different background. Law school in that sense is pretty cosmopolitan. People come from places which, they're speaking throughout in English, writing throughout in English. But there are also people who are coming, who've done their 8th and 10th in Hindi medium or local boards, and then have switched to English. And they find it hard in law school. But when it comes to getting job in the fifth, after the 5th year, or when it comes to the profession, everybody is equal, really. So those people who feel that their language is not very well, they have to work on it throughout their 5 years. I've had classmates, who worked very hard in improving just their language. I remember seeing one of the English storybooks, or maybe it was something else, where, difficult words were underlined and there were meanings written on it. That is how people have spent time reading and improving their language. And if you're able to discern that this is my weakness, this is something that is going to hit me, you have to work hard on it. Because if your language and your communication is sorted, the rest of the things will follow. Because like I said in the opening part of my discussion with you guys, that it is very important for you to know where to find the law. So once you know where to find the law and you know how to communicate, everything else just will follow. Right? And that's really the key to utilizing your 5 years here and utilizing your time here.
That was very insightful. One thing that really struck me about what you said was you'll be the best communicator by following the model of what, when, how. That is something that really struck me. And one more point was that when you said while you spend your time here for 5 years, you really have to take the interest for yourself.
Yes.
To write down, to sit down and write. And it brought back what something Alok Prasanna sir once said in a writing workshop, that the best time to write is now. And in his workshop, he also brought up the point that if you really want to improve your writing, like how you have said, it's harder to write it brief, right?
Yes.
He suggested that we take a Supreme Court judgment and just try to write whatever the length of the judgment may be, just try to write it within 10 pages. So I just wanted to ask you more on, do you have any such techniques where students can, like this seems like a fun activity to do on a good Sunday, right? Any such techniques where, students can sit down and actually write? Like, it is one thing to say you just have to learn and write, you just have to write it brief, but it's other to, experiment with it.
No, I quite see your point, Rashmi. I quite see your point. And you see, that is something that I also find missing in a lot of CVs that I get for internships, and even for, people who are wanting to work with me. I feel that a lot of people are just spending a lot of time getting and working in their internships in the hope that I have to know the practice. I have to know how, things are drafted, and how I have to know how research is done. But the real thing is, are two factors that are very important and which I find missing, and I'll come back to your question. Number one is legal profession is entirely self-sustained and motivated. Because legal profession, you are practically like a if I must use that word, like a mazdoor on first day, right? If you want to be a good carpenter, you have to take the tools in your hand, and that is what a good chamber is about, giving you the tools, right? But then using the tools, you have to watch and learn. You will be given, wood to chop, right? You will be given briefs to read, to work on it. But really, it's about you becoming a better carpenter every day. So in that sense, number one, it is your own self-sustained tempo or enthusiasm that is going to bring you to work and take you back home and bring you to work, even at odd hours, right? So that is something that, now, how do we as lawyers see that, whether this motivation is there or not? And I'll come to your question. How do we as lawyers see that this motivation is there or not? We really, and I'm sure that's true for other recruiters also, we look at what has the student done outside of the things that are thrust upon him. To pass the course, to make a project is mandatory. You will not be, probably allowed entry in your home if you failed a couple of subjects, right? For most of us, right? So we have to answer to our parents that what is it that we are doing, why aren't we studying? So that is the basic for which you are here, and you will do it. The question is, what is it extra that you're doing, and why should you do that extra?
What drives you to do that?
Yes, so that extra is something that is reflected in your CV. You may say, I have done extra internships, right? Well, that's one way of looking at it. Some people have done 4 internships, some have done 6. Some people have done 14 internships. Even in Dussehra and Diwali, people have done internships, right? But that is towards, trying to, make a network so that you get a job. It's not necessarily, I'm saying not necessarily to improve your own self. But once you do a moot, for example, it's not compulsory. In most law schools that I know, it's not compulsory. Or once you start writing, you join a law review, you take that additional burden upon you that I have to check other people's draft. I have to do, something with it. All of that is your additional enthusiasm that is reflecting here. It is a signal to me that this fellow is, even if hopefully, if this thing continues, if recruited, then if I tell him that, look, give me a case law that says this, right, or draft a written statement, he will maybe also look around and say, no, written statement cannot go without admission and denial, so I must also make additional admission and denial. so that when the work comes to me, I don't have to cut a sorry figure that I forgot to tell you that, admission ke saath, written statement ke saath admission denial is also something that you have to make. Because that's the extra that you've always been ready and willing to do. So, and the same happens when you're doing some bit of legal writing. Legal writing is not mandatory. To publish is not mandatory. To attempt law review article is not mandatory at all. Even if you don't do it, you are good enough to go as a graduate in law. But once you've attempted to do it, maybe you're unsuccessful, you try again. And assuming that you get a few publications on your CV, it shows to me that you're willing to do something extra. That, outside of the compulsory things, I'm also exploring something else. Right? So that shows to me that you have an interest in the subject, that you will eventually, if I am asking you to do X, you will do a little extra X plus Y also, you will do it because you're, yourself interested in finding the answers. So to answer your question on what should the students write, if I tell them that, look, you summarize the judgment or you rewrite this or recreate this, it's defeating the purpose. Because it has to come from you. You feel very strongly about something, you write about it. You feel very strongly about what's happening in Ladakh, you will read the law on preventive detention, you will read all the judgments on preventive detention, you will see the commentary, you will see Sirvai, you will see what other people are saying, and you will try and make a head and tail of this, what is happening. Because eventually, after all, Article 22 is just one small 2-mark question in your entire con law paper. If at all you get that question in your exam paper. But to read about the law of preventive detention, what are the grounds should be communicated, which language, what can be the considerations, what are local laws on this is little extra that you have to study. If you are enthusiastic about it, if you're enthusiastic about what's happening around you, you convert it into an article. That shows your inclination to find answers. Right? And at the end of the day, what are we all doing? We are finding answers for our clients. Right? So idea is to cultivate that mindset to be able to find answers. So, what I've realized is in this legal profession, broadly 2 or 3 categories of lawyers. One who are asking others, this is a client, this is what I have, what should I do? The others is, they will read, they will find out more, they have no client, but they're just reading. And there'll come a time in the second category of person who have clients will ask the first category of students, I have this client, but I don't know what to do. Then that person will say, okay, look here, look there. You will find your answer there. And it's the first category that eventually brings respect for your knowledge, for your hard work, and it pays. So to write is something that has to come from you, from within. And it requires a little bit of discipline, little bit of, trying to take out time. And it's all extra.
So, I'm sorry, please continue.
No, that's all. That's it.
Okay, sir. So you talked about doing moods, areas, writing, but I think there is a lot of pressure also to do it. So, especially I think in NLUs, because everybody is doing everything. So there's a pressure all the time, and that also takes a toll on your mental health. And you have also talked about mental health in your book itself. So if you could talk about how students can handle it, how young lawyers entering in the field can handle it, it would be great, I think.
So I must say that the pressure is there. Of course, the pressure is there. And it is, some amount of pressure is necessary for you to work. Because, not all of us are self-motivated. Sometimes you need little bit of push. But one should not be worried about it. So, the idea really in law school is to try your hands at things like this just to see whether you enjoy doing it. The test is not really whether I win or lose. Test really is whether it brings you joy.
I believe what you're saying is the test is of collecting experience.
Yes.
And see what stuff.
Yes. So for example, internships, I also did a corporate internship. I didn't quite enjoy it. I did lit internship. I quite enjoyed it. So, idea is to also see what else is there and then see what you enjoy doing. So for the moods, etc. So some amount of pressure, yes, but beyond that, the students also have to realize that, look, it's not a do or die situation. If I enjoy doing it, I'll do it. I'll put my best in it. Some people enjoy photography. Some people enjoy, doing something else. It's up to them entirely. They may not be motivated to do ADR, moots, etc. There's no pressure really. I mean, I don't see that as a sine qua non. But when it comes to, so the thing is that your career will have to be then molded accordingly, right? And then you will have to choose things that allow you to do things that you enjoy doing. So in law school, you may graduate as a lawyer, but a couple of years down the line, you may choose to become a civil servant, or you may choose to start a travel agency. You may choose to be a photographer, or like one of my seniors is playing full-time cards in Goa. So that's also a life that he's chosen. So, people just do what you enjoy doing. That's the key. Quite apart from that, once we get into the jobs, because many of us also have loans, etc., to pay off. So in that situation, you have to actively learn things that help you cope up with the challenges that come every day. You have to learn a bit of yoga. I have not learned that. I have, and I have really killed myself in last 10 years. And I honestly, I regret working a little too hard on myself. I should have paid more attention to my health. And that's the reason when I get interns, and those who have interned in my office will realize that, the overall setup of my office is slightly light. Some juniors may disagree though. I also, I try to give myself and others, of course, 1 or 2 days off, so that, there's time to recuperate. I would actively encourage lawyers in their 4th and 5th years to, it's early on, they may think that it's pretty useless, to, learn some meditation, some specifically deep breathing. It really helps, and that's something that I got closer to after COVID, because I had a massive health issue post COVID. So I realized that things like this really help. It also sharpens your memory and things like that. So these are techniques that you have to learn in advance. And of course, one thing that has to happen in law school, and I think it may have happened a great deal since my time, is to just to make sure that there is no taboo about mental health. That if you're feeling anxious, you have to communicate. You are upset about something, communicate. You have to have that sort of comfort should be there with everyone, that अगर मैं किसी से बोलूँगा तो people will not judge me. At least my friends are not going to judge me. In my batch, we've lost a friend to something that that should have been sorted out very easily had he opened up to us as classmates. And something that I remember is one of my classmates said that we are all friends, but we are inadequate friends. We are not sufficient, because while we are all friends to party, but when we want to speak to somebody, they're just not there. So things like that should not happen. We have to also watch out for each other. So I think that's something that when you live with somebody for 5 years, that kind of equation you should have with your colleagues, your friends, where you let them, you have to understand and sort of take the lead.
So from this, I believe that personal anecdote must have really impacted how you view mental health, and also the way you have structured your own chambers.
Yeah, of course. Yes, I have actually structured my chamber. Something that I still grapple with is like Monday is like exam day for all of us, because Monday is the court day, and matters are listed. So then the challenge is whether you keep a Sunday off or you keep a Saturday off. So that challenge I'm still trying to figure out, but I do want to have 1.5 day off. So, and it so happens that for some it's Sunday off, for some it's Saturday off, for some it's neither. So I'm still working around that. I'm sure at some point I'll strike that balance, but I'm conscious of this.
Right. One more thing I picked up from what you've said is you've emphasized on figuring out what you enjoy. As someone who's studying law, you said you have to figure out what you enjoy. And for some of them, litigation is perhaps very enjoyable, but there are some challenges, like like in contemporary days, the remuneration is low or the interns are not paid stipends at all. I would like to know your thoughts on it, or about the culture of it, and also probably how you could address it.
That's true. You see, to be very honest, litigation is tough because it comes with its own set of challenges other than just what you mentioned. One thing is there, that the carpenter example that I had given, litigation is largely about gaining your own skill and exiting from the place. Unlike a job, or a corporate setup, litigation is not a job.
Okay.
For those of you filing wakalatnama, it's a responsibility. Even if the fees is not coming from the client, but you can't be relaxed, right? You can't say that fees is not coming, therefore I will not go. It's a responsibility that you have taken. All right, fees is not paid, too bad for you, right? That's one part of it. The second is when it comes to juniors also, to a certain extent, one has to admit that, to most beginners, you see the pay or the remuneration disparity is a lot between a senior counsel and even a junior counsel. So even somebody, AOR like me, between an AOR like me and a senior counsel, the disparity will still be huge. Right? So even for one entire case, the AOR will not be paid as much as, the senior is going to get for a hearing. And that is true also from the client's point of view. Reality is that the clients are happy to pay the seniors, but they are not happy to pay younger advocates. And that's the reality. Right? So what we have to ensure is that once people from our time and age become the senior advocates, at that point of time, they are in a position to really correct this thing. But for me to tell an 80-year-old man that, look, now you should fix it, it's difficult because he has grown up in a different kind of environment.
True.
Right? But the younger lot of seniors who've, from NLS grad or Nalsar grad, they are, in terms of how much they are paying, it is better. Not at par, it cannot be at par with law firms, because you have to also appreciate that the seniors it's not a job for you. They are not trying to make your life cushioned, because the goal is that you will learn whatever skills you have to in 2 years, 3 years or 1 year, and then get out from there and establish your own practice, right? You are a horse. At some point you will bolt away. Right? It's not a place where they have to keep giving you sweets and candies to make sure that you stay back, because they have to finally retain their client and they want to retain it for your client. That's not the idea. So the profession is structured entirely differently. And from day one, you're an independent contractor. The term independent contractor in contract law.
Yes.
Right? You are basically attached to somebody. So even many young lawyers, when they come to me, and that's one of the reasons why I wrote this book, is because I got very frequent queries from people. I told them that, look, try and join chambers which allow you to do your own work. Because if the senior objects that you should spend all your time helping me, or senior saying, all right, the day you have some of your own clients, just make sure that somebody from the office fills in for you, and then you go handle your own work, or you handle your own client. That is your real earning, your client. Right? Now you may not know the way to go about it. How do I answer this question from my client? My client has given this query. How you can obviously come up to your senior and ask him for free. Right? In some offices, you can also use your office, use your own office, senior's office staff, or his filing credentials to file something, discuss with him, make sure that he reviews your drafts. Those are the soft benefits of working with somebody like that. But at the end of the day, you are your independent contractor. You are your own carpenter. You have to learn the skill. You have to get your client. Right? The idea is that you do it and you exit. And there should never be a competition from somebody in the corporate sector. Because the territory is completely different. Right? It's completely different. Maybe 8 years, 10 years down the line, you will think that, maybe I should have joined the firm, maybe I would have been remunerated better. But the joy of arguing, or the joy of representing your own client, or the joy of contributing to the law that you are going to get, maybe that fellow is never going to get. They will have all the money, but the joy that you get in this profession, you will never get. They will never get. And that's not a fair competition, because maybe what excites you doesn't excite them. Right? So I mean, the mindset is different. Right? So there's never going to be a parity of pays between litigation, A0s, A1s, with A0, A1s of firms. Right? But you will be the master of your time. You want a Dashera break, you want to go home, go home. You want a summer vacation, you want to go home, because the boss is going to go travel. He will say, what will I do with you in my office? You also go home. They are not going to get that time to visit their parents for 10, 15 days at stretch. You are going to get that time. So you have to value these flexibilities also that you get in this profession. So it's a completely different set of rules, completely different benefits, and at the end of the day, it's also a gamble. Because what if you don't make it a big senior counsel in your 40s or in your 50s? It's a gamble. But if you've enjoyed your life, that's totally worth it. Yeah.
So. That was really insightful, and in a way very thought-provoking. That have you sort of demystified the idea that litigation is not a job? It's on the lens of higher responsibility, right? And also, it was really insightful.
Thank you, Rashmika. Thank you.
So even in your book, you have written about, while I was reading it, that when 40 to 30% of your work is not what you are working for as a senior, you should start your own practice. And this is something I did not even think of, because your perspective in the book and what you have said right now, that it's a responsibility which comes in, is very new and very enriching for all of us.
Thank you. I'm glad that you found a few things useful in that book.
Yes.
Thank you. Thank you.
With this, I think we come to the last question of this podcast, that what value do internships hold? Because everybody is running after internships. And with this, I'm also interested to know that what is the process of applying for an internship under your guidance, because I believe so many students would be interested in that. And what opportunities do interns working in your chamber get, and what do they learn through it?
So, Tamanna, I feel that what interns get out of internship versus what the person who is giving internship gets out of the interns, these are two different things. While the interns want to intern, the person who is taking you as an internship may have a different approach to why he wants an intern. I will not say it, but everybody's approach is different to how they, what their expectation of interns is. What I have had two kinds of interns broadly, and I still follow that. One, that I feel that I can invest my time, energy. The others, I see that they are not very sincere, and they are there, but I don't get drafts in time, or I don't get research in time. So I know that they are here for the internship. So I respect that. But for those people who identify as people who are on their toes, are asking me questions about things, are interested in the what's happening in the chamber, what matters are listed tomorrow, where can I help, that's kind of people who are forthcoming. Those people, then I try to have a longer term relationship with them, and then I sort of get back to them that if you're doing well in life, you have some questions, or how can I help you further. So I do that. So my internship then for certain kind of interns then translates into mentorship. There's no real criteria. It's all on the spur of the moment. You could say arbitrary, but also there is some experiential analysis that happens, and then that relationship develops. That's one part of it. The second is as for the interns, I try to ask them on their first or the second day, then what is it that they expect from my internship their internship at my office. Some say they want to do research, some say they want to do drafting, some say that, they would like to work on a particular kind of cases. I make a note of that. Then I try to, give them work accordingly. And to those people whom I give some drafting, I give drafting, by the way. And I tell them, first thing in my office is that I try to have interns from senior years, people who've studied con law, specifically administrative law and CPC. And the reason for that is that at my stage, I just don't have the time to teach basics, something that you should have, studied in law school. But yes, if you've done these subjects, then, the second part of the practical part I can take care of. So once I have students who have done these basic kind of subjects, maybe Con Law 2, Con Law 1 and Administrative Law and some bits of CPC, then I give them drafting and I tell them that, look, I'm giving you a precedent. I'm also discussing with you that what is it that I would like in this petition as main points of focus. But I will treat my interns at par with associates. Don't think that you can get away with anything because you're an intern. Don't tell me that I have not studied this subject and therefore I'll not be able to, work in this area. And that's really I don't know whether that put pressure on them, but the reality is that it's quite pointless because even an A0 could be saddled with work that they have not done before. Could be saddled with demystifying statutes that they have not been taught in the classrooms. So I feel that so long as you know where to find the law, so long as you can read English, so long as you can comprehend instructions that are given to you, you can mix all three and find your way and find the answers. And that's really what the practice is about, finding answers. I'm repeating it the third time in different contexts, but that's really the key of it. And then I give them drafting work. And then if drafting is done, drafting comes early on in their internship, then my objective is that before their internship finishes, we file that matter and that matter gets listed. So they get to see the end to end of that matter, or at least till the notice stage they're able to see that, what are the problems, defect mein kya phasta hai, if there is a feedback, what is the kind of feedback. Right now, even though I'm trying to minimize that, but with my associates and also with my interns, we sit on the same computer and then, they see the corrections that I'm making. There are points that I keep, points that I remove. My associates and so are my interns are free to ask me question why something has been removed and why the language has been changed. If they put in something, I also ask them why have you put this and not that. So, it's in that sense a collaborative exercise. So where, they get live feedback of what happens mostly. This is 80-85% of how I deal with that.
It's really wonderful, sir, how you put the associates and interns on the same pedestal. It also shows how much of faith you put in those students, and that, flick of faith every student really needs to believe in themselves and, to work relentlessly towards their passion.
Well, it's the other side of the coin of, being a responsible lawyer. Because if I've signed a wakalatnama, if the client has entrusted all of his, hopes in me, I have to do my best. And by that logic, everybody who's associated with me have to do their best. My clerks have to be on their toes, because in Supreme Court specifically, it doesn't give you a second chance.
Right.
It's the final court, so, there's no scope for mistakes. And it costs people heavily for mistakes.
Right.
So I try to minimize that. I can't, guarantee that then I don't make any mistakes. But then, of course, I try to minimize it. And I do it with the understanding that, this is the final code. In many of the cases, for example, we were doing not that there's any mistake there, but, for example, the cases of, say, murder conviction, or, just a couple of years sentence in jail, or citizenship cases. These are cases of irreversible consequence for the entire family. So even though you may have one petitioner, but the impact of that decision is huge on the whole family. It has the capability of either making or destroying a generation. So it's a very responsible work that we do, and once again, and that's how it differs completely from anything else that you may be saddled with as a part of the team, where this place for you to become invisible. But in litigation, specifically in a smaller office like mine, it's just very difficult.
Right, sir. So throughout the podcast, you have extensively covered about bridging the gap between theory and practice, about the use of AI, about mental health concerns, and I think this is going to help all of the law students watching this and all of even the young professionals entering the field. And I really hope it motivates some people to choose litigation, and with the NLU curriculum geared towards corporate, I really hope that some of the students do get motivated.
Yeah. Just to add to her, and as we wrap this up, thank you so much for taking the time out to talk to us in the first place, because I've read one of your interviews and there you said, I'm writing this book so that it reaches places maybe I cannot reach. Like book can reach indefinite places, and I hope given this digital age, this podcast reaches more people maybe even the book cannot reach. And I really hope all the invaluable lessons that you have shared with us are taken and carried forward by the listeners.
Thank you, Rashmika.
It was a pleasure having you, sir.
Thank you.
On behalf of the Nyaya Forum of Lawyering,
I thoroughly enjoyed being back on campus,
Yes,
back to my own law school.
Alma mater.
Thank you.
It's almost homecoming.
Yes, thank you very much.
Thank you,
Thank you
sir.
so much, sir.